Hello viewers, I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In the present module, we will learn about the judicial reforms of Lord Cornwallis. My dear viewers, the objectives of the present module are firstly, introduction, then first stage judicial plan of 1787, then second stage judicial plan of 1790, third stage judicial plan of 1793 and finally the conclusion. Dear learners, let's begin with a brief introduction of the topic. Lord Cornwallis was a British Army officer, administrator and diplomat who had previously served his country during the War of American Independence. In 1786, he accepted the offer to take up the post of Governor General of Bengal on the condition that he be given the supreme military command as well. He arrived in Calcutta on September 12 and took charge. Lord Cornwallis succeeded Warren Hastings as the Governor General of India. In Indian legal history, the years of Lord Cornwallis' Governor Generalship are regarded as exceptional. He was the first Governor General of India to be subjected to Pitt's India Act. He was a nobleman of high status with an aristocratic demeanor. He founded the Indian Civil Service. Between 1753 and 1762, he had the title Viscount Brougham, and from 1762 to 1792, Lord Cornwallis went by the name Earl Cornwallis. Following his return from America after the War of Independence, Lord Cornwallis was offered the position of Governor General. With his selection, a new custom of selecting an aristocrat for the position of Governor General was started. Lord Cornwallis was lucky to have a team of highly skilled and experienced individuals working for him, including Sir William Jones, John Shore and James Grant. Even though Cornwallis began his job in a favourable environment, he had to implement his policies with considerable care. Let's discuss now the administration of justice under Lord Cornwallis. The Parliament revised Pitt's India Act in 1786 to give him the authority to, if necessary, overrule the majority vote of his council, and it was willing to grant him exceptional legal powers to enact radical reforms in the administration of Bengal. His aims as Governor General were to uproot corruption from the present judiciary and the administrative system, to tackle the problem of land revenue, to develop a proper system of administration of justice. The reforms of administration of justice under Lord Cornwallis can be discussed in three stages. First stage, judicial plan of 1787. Second stage, judicial plan of 1790. Third stage, judicial plan of 1793. Let's begin with judicial plan of 1787. The company was dissatisfied with the existing judicial system of Warren Hastings, as it had separate revenue and judicial functions. This separation was expensive. It also created conflicting and overlapping jurisdictions. Lord Cornwallis submitted his first idea in the year 1787 on the orders of the Court of Directors to consolidate revenue and judicial powers under a single body known as the collector. Let's discuss the appointment of collector. A collector was appointed in each district. He was an Englishman. Collector was assigned with two tasks, firstly to collect revenue and secondly to decide cases arising out of revenue matters. He also presided over the Mofussil Diwani Adalat, that is district level civil court, as a judge. In Mofussil Diwani Adalat, he would decide civil cases and cases of jamidars. Appeals from the Mofussil Diwani Adalat lay to the Sadar Diwani Adalat when the matters exceeded rupees 1000. The Sadar Diwani Adalat was presided over by the Governor General. He also presided over the Magistrates Court as a magistrate, where he was empowered to try and punish cases of petty crimes and offences up to rupees 200. Offences having value of more than rupees 200 would be sent to the Sadar Nizamat Adalat by the magistrate. Next, there was reorganization of districts. The number of districts in Calcutta were reduced from 36 to 23 to affect the economy in the administration. There was establishment of Mal Adalats. Mal Adalats were established in each district. The collector in each district was to collect land revenue and decide revenue cases in his Mal Adalat or revenue court. The decisions of this court were appealable first to the Board of Revenue at Calcutta and then to the Governor General in Council. Then there was establishment of registrar courts. An assistant officer of the collector was appointed who was known as the registrar. He was appointed in each district who presided over the registrar's court, which decided civil cases up to the value of rupees 200. But the decree passed by the registrar was not final until it was signed by the Mofussil Diwani Adalat, that is the collector. What were the defects in plan of 1787? The main defect of the plan of 1787 was the combination of so many powers in the hands of the collector. Though collectors were given handsome salaries, they still abused their powers to their own advantage. There was no effective control and supervision over them. Thus, the collectors were despots in their districts. In fact, the plan of 1787 was a retrograde step in view of the progressive step taken in 1781 by Warren Hastings, when a separation was effected between judiciary and revenue functions. The situation was, however, improved in 1793 when Lord Cornwallis restored the earlier position. Dear viewers, now we will discuss the judicial plan of 1790. The system of administration of criminal justice was quite defective. Three types of courts were created in the Mofussil area. Inordinate delay was caused in the disposal of cases by the Mofussil Nizamat Adalats and Sadar Nizamat Adalats. Numerous robberies, murders and other crimes increased on account of delay which occurred in bringing the offenders to punishment. With a view to ensure a prompt and impartial administration of criminal justice, the Governor General in Council resolved in 1790 to assume the superintendence of the administration of criminal justice throughout Bengal, Bihar and Odisha, and formulated the following scheme. Firstly, Court of District Magistrate. The collectors in the district were to act as magistrates. Upon a complaint made in writing and sworn to by the party making it, the magistrate had to issue a warrant specifying the nature of the charge for the apprehension of the accused. The statement of the complainant, accused and all the witnesses had to be reduced to writing. If the offence was proved on evidence but was a petty one like assault, abuse or affray, the magistrate could punish the offender with inflicting a 15 or lesser number of whips, imprisonment up to 15 days or a fine not exceeding rupees 200. The cases involving offences of serious nature were sent by the magistrate to the court of circuit. Then there was reorganization of districts into divisions. The Mufassil Nizamat Adalats were abolished. The whole Diwani areas were divided into 4 divisions of Calcutta: Murshidabad, Dhaka and Patna. Then there were court of circuit. In each division, a court of circuit was established. The court was supervised by 2 English judges, assisted by Qazis and Muftis, who were to be nominated by the Governor General in Council. A complete record of the proceeding of the court of circuit was to be transmitted to the Sadar Nizamat Adalat. Let us discuss Sadar Nizamat Adalat. It was shifted from Murshidabad to Calcutta, where it was judged by the Governor General in Council with Muslim law officers assisting them. The 1790 system functioned admirably. The only flaw found in the system was that the courts of circuit were asked to manage enormous amounts of work. As a result, Cornwallis enabled magistrates in 1792 to impose punishment in situations punishable by up to 1 month in prison. The pressure on circuit courts was relieved as a result of this. Lord Cornwallis also made certain humane measures, such as providing allowances to prosecutors and witnesses who appeared in the court, abolishing the clause for attachment of property, and allowing offenders to be rehabilitated. Sadar Nizamat Adalat was empowered to pass a sentence of death instead of granting blood money to the heir of the deceased. The relatives of a murdered person could not pardon the offender. In 1792, the rule was that the refusal by the relatives of a deceased to prosecute a murderer would operate as a bar to his trial was abrogated. The punishment of mutilation was abolished. During this period, it was also provided that the crimes of forgery or perjury should be punished by branding on the forehead in addition to the ordinary punishment. There was increase in salaries. The salaries of all judges of all courts were fixed and increased to control corruption that was prevalent in the current system of justice. Now, collector was to make a report of the working of courts. Collector had to prepare a report of the working of courts he was in charge of, that is, the magistrate, Mal Adalat and Mufassil Diwani Adalat, and send it to the British Parliament of England biannually. The post of Nawab was abolished. Cornwallis resolved to abolish the authority of Nawab over the criminal judicature and to transfer the administration of criminal justice from Muslim law officers to the company's legal servants. The post of Nawab, who used to preside over Sadar Nizamat Adalat, was abolished, as he did not carry out criminal justice properly, and it was now presided by the Governor General in Council instead. Court fee. court fee was introduced to reduce the burden on courts. Court fee was only charged for pleaders of the court and for calling the witnesses of the case. A questionnaire to the magistrates was sent asking for their opinions on the prevailing criminal judicial system. The magistrates' opinion in the questionnaire sent to them revealed the evils of the criminal justice system. This made Cornwallis realize that certain vital changes were required in the system of criminal justice. As far as the defects of the judicial plan of 1790 are concerned, the plan of 1790 was a great improvement upon the prevailing system. It was based on the principle of check and balance with Sadar Nizamat Adalats supervising the working of the courts of circuit and later supervised magistrates. Thus, the plan introduced efficiency in the administration of justice. The scheme of 1790 put the whole system on a sound footing and ensured to some extent the security of life and property of the inhabitants. However, there were gross defects in the Muslim law of crimes. Court of circuits were moving courts which were overburdened with cases, which caused them delay in moving from one district to another and could not visit some districts twice annually due to the delay. There was a lot of collective power of administration and judiciary vested with the collector, which made him abuse his power. Next is Judicial Plan of 1793. Lord Cornwallis was in favour of the doctrine of separation of powers. He separated the judicial functions from those of revenue. Separation of executive and the judiciary. The powers vested in the collector were administrative and judicial, as he was also in charge of collection of revenue and for deciding cases arising out of revenue matters. Now, the collector was only responsible for the collection of revenue. Mal adalats were abolished. Revenue courts, which exclusively tried cases arising out of revenue matters and presided by the collector as judge, was now abolished. All powers and pending suits of the revenue courts were now transferred to Mufassil Diwani Adalats and thus not tried by the collector. Executive subjected to judicial control. The Governor General and his council were now subject to judicial control. Any wrong acts committed by them while carrying out their functions and outside of it could be heard or tried and punished by the Diwani Adalats. Suits against the government by private individuals could be brought forward and were tried by the Diwani courts. Indian natives had to sign a bond with the British subjects agreeing to go to court. The British could recover claims from Indian natives and vice versa by signing a bond with each other agreeing to go to a court. There was establishment of provincial courts of appeal at the 4 divisions. Earlier, the appeal from the Mufassil Diwani Adalats lay to the Sadar Diwani Adalat situated at Calcutta, but this process was time consuming and expensive. So, provincial courts of appeal were established at each division, that is Patna, Calcutta, Murshidabad and Dhaka. Appeals from the Mufassil Adalat now lay to the provincial court of appeal, which were to be heard within 3 months of filing them. These courts were presided over by 3 covenant English servants of the company. Quorum was of 2 servants. It was an open court and could try revenue, civil and criminal cases. They could also try cases referred to them by the Sadar Diwani Adalats. Cases valued more than rupees 5,000 were referred to the king in council. Now, native officers were given important posts. Native officers were appointed by the Governor General in council. Native officers were made munsifs of the munsif court at district level. This court could try cases up to rupees 50. Zamidars, tehsildars, etc. appointed as munsifs. Personal laws of Hindus and Muslims were applicable in cases relating to marriage, inheritance, caste, religious usages and institutions. These personal laws were interpreted by the native officers who were appointed to assist the court to expound the personal law. Next is Sadar Diwani Adalat. It was the highest court of appeal in India. It was presided over by the Governor General and the Council, who were the judges of the Sadar Diwani Adalat. Their function was to supervise the lower courts and to hear appeals from the provincial courts of appeal when the sum of the matter of the case was more than rupees 1,000. Further, an appeal from the Sadar Diwani Adalat lay to the king in council when the sum of the matter of the case was more than rupees 5,000. Reforms in criminal judicature. The Court of Circuit was merged with the Provincial Court of Appeal. The power of the collector as a magistrate was taken away and was vested in the judges of the Diwani Adalats instead. There was uniform pattern of regulations. Until now, any new regulation that was issued did not follow an uniform pattern. This was changed by making it a rule that any new regulation that would be made would have a title to explain the nature of the subject matter and contain a preamble which would state the purpose for enacting the regulation. Reforms in Muslim personal law. The Sadar Nizamat Adalat was directed to follow the Muslim personal law to try and punish criminal cases, but with some modifications. The relatives of murder victims did not have a provision to pardon the murderer. The cruel and inhuman punishments such as cutting off limbs of the offender were replaced with the punishment of imprisonment and hard labour for 14 years. Court fees was abolished. Court fee, which was imposed in the Judicial Plan of 1787, was abolished. The court fees was abolished so that the people could easily reach the court for securing justice. Legal profession recognized for the very first time in India. The legal profession was recognized in India for the first time. The pleaders of the case had to have prior legal knowledge to be eligible to be a pleader of the court. Now, what were the defects of the Judicial Plan of 1790? The provision of multiple levels of appeals made by the judicial machinery complicated and slow moving. Thus, a large number of cases remained pending in the courts for a long period. The Indians were totally excluded from the judiciary except at a very low level of munsif. Cornwallis was of the belief that the Indians were unworthy of holding any position of responsibility because of their character. This distrust shown towards the Indians generated dissatisfaction among the native people, as well as made the system less efficient, as the English servants did not know and understand the customs, usages, etc. of the people. Therefore, Europeans could not understand nor provide solutions to the problems of the natives. Cornwallis did everything on the procedural side, but he could not reform the substantive part of law, mainly the criminal law, which was based on Muslim law and had many defects. My dear learners, from the foregoing discussion, it may be concluded that Lord Cornwallis established the framework for British authority over all of India. Up until the end of the British Empire in India, numerous reforms pertaining to the court, revenue and services were implemented. Lord Cornwallis refined the procedure started by Warren Hastings. The 1793 plan was well planned and well executed. The new system was designed around the concept of checks and balances, with executive officers being held personally responsible for their official actions, and a complex system of judicial scrutiny and appeals in place. As MP Jain observes, the plan of 1793 is a standing testimony to the maturity of judgment, the breadth of outlook and the liberality of vision of Lord Cornwallis. Through his various judicial plans, Cornwallis was successful in uprooting the evil of corruption. Though Cornwallis was a just administrator, he was seen as a racial discriminatory, as he reserved all the high posts of judicature for the Europeans. Despite the fact that Lord Cornwallis introduced significant reforms in the administration of civil justice, the problem of criminal law was still prevalent, as the criminal law was based on Muslim personal law, which suffered from many defects. Lord Cornwallis made no attempt to codify Indian law. This was a great omission in his reforms. With this, we come to the end of today's lecture. Thank you very much.